But surely as the only criminal lawyer in the business, there's a suite of criminal law policies here. Wouldn't you put your hand up and say, hold on, that's my job? Are you saying that your performance was monitored by defence lawyers?
That's CLT, isn't it? Are we looking at criminal law team now?
Yeah, we have always been looking at the criminal law team in this set of questions.
Yeah.
Can I just get this right, Mr. Singh? In answer to my question, how over a 17-year period as a prosecution lawyer was your compliance with Post Office policy monitored? You've answered by defence lawyers. You're not involved in any prosecutions, you told us. That's Cartwright King.
Yeah.
You're not involved in supervision of any prosecutions. That's Susan and Hugh. You're not involved in maintenance or review of the policies. That's Susan and Hugh. What were you doing?
So, as you can see from the snippets that we've just looked at, there is some exciting testimony coming up from Jarnail Singh to the Post Office inquiry, where essentially he seems to suggest that defence barristers were the ones that kept him in check with Post Office Prosecution Policy and not him. He says he was the owner of the policy, but he didn't create it, he didn't contribute to it, and he didn't monitor it. But it was okay because he had chats with a few people and sometimes people looked at his files, so that was all okay. What Jason Beer's really trying to establish with Jarnail Singh here is what exactly he was doing from a day-to-day basis in his role as the only criminal lawyer in the Post Office. Let's try and unpick it by jumping into the inquiry.
Can I turn to prosecution policies and charging decisions?
Yeah.
In your witness statement, it's paragraphs 19 and 20, you say that during the period when the Post Office was still part of the Royal Mail Group, so this is up to April 2012, files would be prepared by investigators and sent to the criminal law team for advice as to prosecution and appropriate charges, correct?
Where are we? Where are we?
19 and 20.
Okay. Do you want to put it on the screen, or can't we put it on the screen?
Yep.
There's no need.
Put it on the screen if you want.
Yeah, let's see.
Witness statement, page 8, foot of the page. Foot of the page. Do you want to read those to yourself?
Where are we? Number 20 or 19?
Both.
19.
And so my summary of that was, in paragraphs 19 and 20 of your witness statement, you described that during the period when the Post Office was still part of the Royal Mail Group, i.e. up to April 2012, files would be prepared by investigators and sent to the criminal law team for advice as to prosecution and charges. Is that correct?
Yes.
Right, good. That can come down then. In paragraph 3 of your witness statement, you say, as a criminal prosecutor, I will always do my best with the knowledge and evidence that I have in front of me, and at the time of each sub-postmaster case, I followed the relevant codes, policies and procedures, and genuinely thought I was doing the right thing. Is that right?
Yes. Yes.
And in
Well, he has to say yes to that, doesn't he? Because if he doesn't, he blows an entire new case into the air about not acting ethically, doesn't he? So I guess his answer isn't surprising to that.
Paragraphs 12 to 15 of your witness statement, you refer to policies governing prosecution and charging decisions and the conduct of prosecutions. And you tell us that you were not involved in contributing to or developing any of the policies that you list.
That's CLT, isn't it? Are we looking at criminal law team now?
Yeah, we have always been looking at the criminal law team in this set of questions.
Yes.
I'm talking about before April 2012.
Yes, yes.
So you were not involved in the development of any of the policies that you list in paragraph 14?
No.
Sorry, in paragraph 12?
The criminal law team, no.
You were not involved in any of the development of those policies, nor contributing to them?
Not that I'm aware of, no.
That's changed a bit. I feel like Jason Beer's got something up his sleeve here.
And you tell us in paragraph 15 that although you're described as the owner of a policy, that simply means that you adopted the policy on behalf of the Post Office.
Yes.
On its separation from Royal Mail Group, is that right?
That's right, yes.
Well, someone could put that another way and say that means you're being put in charge of the policy, couldn't they?
And so if we saw policies with you listed as the owner, that does not mean that you contributed to the content nor approved of the content, is that right?
Apart from 1st of April, year 2012, I'll be very surprised if there is one.
You tell us in paragraph 16 that the aim and rationale behind sub-postmaster prosecutions was both to hold the offender to account and to deter potential offenders. Yes?
Yes.
How was compliance with the policies monitored?
How do you mean? Can you sort of elaborate a little bit so I can help you?
There are a series of policies
Yes,
that say when you're conducting investigations and prosecutions,
yes,
you should do these things.
yes.
How was compliance
Well,
with those things assessed or monitored?
When I advised, I think it was all to do with the prosecutor's code, basically. I've obviously read them when I joined the criminal law team and subsequently, but as far as the monitoring side of it's concerned, that wasn't part of my remit. I didn't get involved in it. Certainly, I made the results known on every of my cases as to how they were put together, who put them together. It wasn't part of my employment or part of my role.
So, if he, as the only member of the criminal law team, upon separation from the Royal Mail Group, isn't owning the policies, even though he's listed as owner on the policies, but isn't monitoring or assessing whether they're being kept to, and Cartwright King aren't being managed by him, or any other third-party law firm aren't being managed by them, then how can they be sure that any of those policies are actually being followed, apart from he himself, who he says after separation wasn't taking part in any of the sub-postmaster prosecutions because they all were handed over to Cartwright King?
What about you not as the monitor, but as somebody who was monitored?
If I was, it'd be appraisals. I think we had appraisals every 3 months or every 2 months, and I think certainly when I was away, people looked at my files, the advices I gave, and I think some people who went to court on a certain case said it was one on their case, and my case was, for a hearing on the same day or same time they would review it. That type of thing is the only monitoring I can think of. I can't think of any.
And by that, do you mean monitoring your advocacy?
No, I mean they would physically have my file in front of them. And certainly Rob certainly looked at it, because I think appraisal times or subsequently, whereas when he looked at it, he would advise on it. You should have done this, you should have done that. Be careful on that. And I think once or twice he might have even said, look, this is the way you should have done it. Why didn't you consider that? So that was the sort of way it was monitored. There was no set, procedure or.
So it was chats, essentially.
I don't know. I don't know what he did with it. I don't know whether he subsequently reported further down to his line managers. I don't know, but certainly.
I'm talking about between August 1995 and April 2012. So there's a 17-year period.
Yeah, there's
I'm asking you as a lawyer how you felt that your adherence to policy was monitored and assessed.
Certainly when the matter is before the courts, then we briefed counsel because they had the right of audience. We didn't. They certainly came back, with their own advice and opinions. Then you had a lot of the time, maybe a lot of even the defence lawyers come up with all sorts of, in their defence statements.
Are you saying that your performance was monitored by defence lawyers?
Well, not monitored, but then you can see from the way they're responding to it, you're engaging with them in that way. But certainly internally, it would be appraisals by the head of criminal law team.
Did the defence like what I advised the prosecution to say? And that's the monitoring of our performance. Well, no wonder the defence had complaints, because it sounds like a bit of a free-for-all unless they raised an issue.
Can I just get this right, Mr. Singh? In answer to my question, how over a 17-year period as a prosecution lawyer was your compliance with Post Office policy monitored? You've answered by defence lawyers.
No, that's one of the things I mentioned, and so you learn from it, don't you? As and when somebody's reacting to it, but certainly it would be appraisals. I think every 3 months, every 6 months. I don't know what now, and certainly we had conferences with the barristers, and they do the advocacy. They would do the opinions, but I don't.
Appraising your performance and monitoring your adherence to policies seem like two separate things, although I accept your following of policies could form part of your appraisal, but that's not its primary purpose, and you would think there was some safeguards in. saying if we're going to introduce a policy, we need somebody to manage this and own this and make sure it's being implemented to ensure it's being followed. Otherwise, surely it's not being. But at the moment, what he seems to be describing is a bit of a trial and error, and basically saying, well, if the defence kicked up a fuss, then clearly we're not sticking to the policy. And if they don't, then we must be sticking to the policy, which seems very flimsy to me.
I don't know what my line manager did or what he did with the others or whatever, but certainly it would have been the line managers who would deal with it, or the team lead, head of criminal law.
What about from April 2012 onwards, when you were the sole criminal lawyer within Post Office Limited? Did you take on responsibility for the ongoing review of all Post Office policies relating to prosecutions and criminal law?
I think that was Hugh or Susan. I think they were more hands-on that.
Hugh and Susan again.
Susan Crichton and Hugh. They in turn dealt with all that. I didn't get involved in that.
Why not, as the criminal lawyer?
I don't know. I can't honestly answer that. I can tell you that I wasn't involved in it.
Was it because people didn't view you as having expertise?
I can't tell what other people thought.
But surely as the only criminal lawyer in the business, there's a suite of criminal law policies here. Wouldn't you put your hand up and say, hold on, that's my job?
I didn't. Well, maybe I should have done in hindsight.
You're not involved in any prosecutions, you told us. That's Cartwright King.
Yeah.
You're not involved in supervision of any prosecutions. That's Susan and Hugh. You're not involved in maintenance or review of the policies. That's Susan and Hugh. What were you doing?
Well, as you say, what I did do was obviously picked up on various aspects of it. Training of the investigation officer, which I did with the Cartwright King. I was involved in getting Simon Clarke to look at the prosecution policy. I was also involved in getting advices on auditors being, how the auditors ought to function, how they ought to deal with their role within the.
So is the sum total here of his involvement essentially the training of the investigators and auditors, which we now know was very ad hoc, very mismanaged, didn't stick to a particular curriculum, shall we say, and that was his sum total of contribution beyond copying and pasting emails, and it went disastrously wrong, and arguably wasn't his role. Mind-boggling.
Criminal law. There was so much there you would not believe. I didn't have. I mean, ideally, I would have. That's what I would have done. I would have basically taken over and then made it my own, but it didn't sort of quite work out that way.